Good evening, all of you. How are you people? Well, the most awaited session is here. I know it would be very useful for you people to have it in the AILET exam. So let's begin with the session. And uh, I know most of the times we keep on confusing ourselves with lot of doubts and queries and everything. But the best part is, the exam is just nearing and we should just focus ourselves really well. So let's move on to the 20 most important legislations of 2020. And see, there would be legislations, mostly bills, because some of them, good evening, Miti, good evening, Khushi, good evening, Kaveri, Saloni, good evening, good evening, good evening, all of you. So let's begin with today's session. Bills hai, COVID-related legislations you people have already seen, but there are some bills that you people might not be knowing about. So let's begin with it. Let's go. The first one is Jammu and Kashmir Official Languages Bill 2020. Okay, and it has been passed by Lok Sabha and Rajya Sabha both. We are waiting for President's assent. They said Kashmiri, Dogri, Urdu, Hindi, and English as official languages to be used for the official purposes of UT for the administrator of UT. And but the use of English as it is being done will continue to be used in administrative and legislative purposes. So this is what the entire bill is about. Right, let's move on to the next one, which is the Foreign Contribution Regulation Amendment Bill 2020. Now, in this bill, it's very interesting. What is foreign contribution? There is already an act regulating it, which is Foreign Contribution Regulation Act 2010. Okay, and the act regulates the acceptance, utilization of foreign contributions by individuals, associations, and companies. Now, foreign contribution is the donation or any kind of transfer of any currency, security of an article, which is by a foreign source. So during this time also we are accepting a lot of foreign contribution, and that is why this foreign contribution amendment bill becomes all the more important for us. Right? So let's move on. What is there in this bill? Prohibition to accept foreign contribution. Under the Act, certain persons were prohibited to accept any kind of foreign contribution. These include election candidates. इसे बहुत अच्छे से समझिए. These include election candidates, editor, publisher of a newspaper, judges, government servants, members of any legislature, political parties, and others. Now, the new bill adds another one segment to it, and that is public servants. Now, the word public servants, as we have already seen, is defined under Indian Penal Code. The same definition of public servants holds good in this amendment bill as well. The public servant includes any person who is in the service or pay of the government or remunerated by the government for the performance of any public duty. So the bill is prohibiting them to accept any kind of foreign contributions even through any kind of public servant. Now, transfer of foreign contribution. Under the Act, the foreign contribution cannot be transferred to any person unless such person is also registered to accept that foreign contribution. अगर आप accept करने के लिए registered नहीं है, then you cannot transfer. But the bill amends this provision also to this effect to prohibit the transfer of foreign contribution to any other person. Now, this part we have amended it already. Now, what is FCRA account, which is Foreign Contribution Account? Under the Act, a registered person must accept foreign contribution only in a single branch of scheduled bank specified by them. तो ये पुराने एक्ट में इस तरह होता था. अब हमने जो बिल अमेंड किया है उसमें किस तरह से हो रहा है? Only the account which is designated, an account which is designated by the bank as FCRA account in such branch of SBI New Delhi as notified by central government. तो वहीं पे foreign contributions आप ले सकते हैं. So this is all about the Foreign Contribution Regulation Amendment Bill. Let's move on to the next one. See, yesterday I've already discussed the wages one. There were basically four bills which were piled up to be passed by the Lok Sabha and Rajya Sabha, and the Code on Social Security is one of them. In 2019, the Ministry of Labour and Employment introduced four bills to consolidate 29 central laws. These were Code on Wages, Industrial Relations, Occupation, social security, and occupational safety, health, and working conditions. Now, we'll discuss one by one all the bills regarding it. And while the Code on Wages 2019 has been passed by the Parliament, bills on the other three areas were referred to the Standing Committee, and that is why it got late, and that is why it is being passed in 2020. The government has replaced these bills with new ones on September 19, 2020. Social security refers. Now, what is social security? Social security refers to the measures to ensure access to healthcare and provisions of income and security to workers. So, this is all about it. बहुत सारी schemes government ने निकाली थी. Some of the schemes were like employees provident fund scheme, employees pension scheme, employees deposit linked insurance scheme. So in all these schemes, they wanted to make a law which consolidate and regulate all these schemes, and that is why we had this bill right now. The schemes, there were certain schemes also for the gig workers, for platform workers, and the unorganized workers. Now, gig workers refer to the workers outside traditional employee-employee relationship, just like freelancers. Freelancer.com में आप जाके you can hire any freelancers. Similarly, these are known as gig workers. Platform workers are workers who access their other organization or individuals using online platforms and earn money by providing them with specific services. So these days, because of the pandemic also and because of the e-commerce industry growing, we have seen a lot of platform workers which are there. So this bill is going to regulate even them. And lastly, the unorganized workers include home-based and self-employed workers. So the bill is going to include even them. It provides social security funds for unorganized workers, gig workers, and platform workers. Now, I hope everything is clear who's a platform worker, who's a gig worker, and who is a unorganized worker. Now, the code specifies different applicability threshold for these schemes. For example, EPF scheme will apply to establishments with 20 or more employees. The ESI scheme will apply to establishment with 10 or more employees. So this is how they have distributed it. For different schemes, they have different rules and regulations that they have made. And before we leave this slide, I wanted to mention that labor law falls under the concurrent list. So just remember that. Let's move on to the next bill, which was the Occupational Safety, Health and Working Conditions Code 2020. This one is also passed in Lok Sabha as well as in Rajya Sabha. And the acts that is trying to replace are the Factories Act 1948, Mines Act 1952, Contract Labor Act 1970. So what is basically this act all about? This code is all about the coverage. The code will apply to establishment of employing at least 10 workers. So this is where the code applies. It will apply to all mines. Earlier, there was a discussion as to this bill would not apply to mines, but currently, while we passed it in the Lok Sabha as well as in the Rajya Sabha, we said that it will even apply to the mines, the docks, the establishments carrying out any hazardous or life-threatening activity which may be notified by central government. So this code will apply to all of them. Certain provisions of the code such as health and working conditions apply to all employees. Health, right to health becomes very important. So just go through that topic once. Exemptions. Now, to which this code doesn't apply. This code doesn't apply to the appropriate government can exempt any workplace or activity from the code in case of a public emergency, disaster, pandemic up to a year. So to these, if central government notifies or any appropriate government notifies that there is a case of public emergency, disaster or a pandemic, so this code will not apply to them. Further, state government can exempt new factories also from the code for a specified period for creating more economic activity and employment. Definitely. Now the registration and license, these establishments, the establishments covered under this code are required to register within these 60 days. So they are required to register within 60 days of the commencement of the code with registering officers appointed by central and state government. So the most important part of this code is basically the hours of working. Now, what will be the hours of working? It should not exceed more than 8 hours a day. Should not exceed more than 8 hours a day. No worker will be required or allowed to work in any establishment for more than 8 hours a day. For overtime work also, if they are working, they must have the consent of that worker and he must be paid twice of the rate of his daily wages. Prior to consent of the workers is required for overtime workers. Now, in this code, very interesting point is that women can also work past 7 p.m. and before 6 a.m. subject to their safety and other related conditions. So this is what the code is all about. Let's move on to the next code, which is Industrial Relations Code 2020. Again, it was passed in Lok Sabha as well as in Rajya Sabha, and it seeks to replace major three labor laws, which is Industrial Disputes Act 1947, Trade Unions Act 1926, and the Industrial Employment Standing Orders Act 1946. Just to mention that you don't need to remember so much. If you are listening to me, it might just get registered and it might just help you anywhere in the exam. Now, the Industrial Relations Code 2020. Now, this code defines what is trade unions basically. So, under the code, 7 or more members. Under the code, they are saying 7 or more members of a trade union can apply to register themselves as a trade union. So कितने लोग apply कर सकते हैं to register themselves? If that union is having 7 or more members, they can go and register themselves. Now, trade unions that have a membership of at least 10% of the workers or 100 workers, whichever is less, will be registered. Central or state government may recognize a trade union or a federation of trade union as central or state trade unions respectively. That is okay. Now the voluntary arbitration part is very interesting. The code allows industrial disputes to be voluntarily referred to arbitration of an employer and workers through a written agreement. After investigating the dispute, the arbitrator will submit the award to the government. This thing is something new which they have added about voluntary arbitration, and there is something very difficult when we talk about labor laws. There are two major things most important things in the labor laws, and that is layoff and retrenchment. Now, what is layoff and retrenchment? First, we'll understand that layoff is the inability of an employer from giving employment to a worker due to reasons such as shortage of coal, power, supply, breakdown of any kind of machinery that he has. Suppose he doesn't have lot of electricity supply, there is shortage of the raw materials that because of which he could not begin with the work. And then what we do is we lay off the employees. And what is retrenchment? Retrenchment means termination of services of a worker for reasons other than disciplinary action. Any person who contravenes these provisions shall be punished between. So this is what retrenchment is. Now what they have given certain new things about them. Employers of non-seasonal industrial establishments such as mines, factories, plantations with 50 to 300 workers must pay 50% of the basic wages and dearness allowance to a worker who has been laid off, and to give 1 month's notice before laying off that worker or before retrenching that worker. So certain good things have been done before laying off or retrenchment, and that is to give them a prior notice. And second thing is to give them 50% of the basic wages and dearness allowance to a worker who has been laid off. So this is what Industrial Relations Code was all about. Let's move on to the next one. The Assisted Reproductive Technology Regulation Bill 2020. Now, this is just introduced in Lok Sabha right now, but quite becomes important for your AILET exam. Now, the bill provides that every ART clinic and bank must be registered under National Registry Banks and Clinics in India. Prior to this, we had no laws relating to assisted ART procedure. We had no laws, regulating it. So now we want that ART should be regulated. The conditions for offering ART services, ART procedures can only be carried out with written informed consent of both the parties. तो ART procedure कभी भी carry out करने के लिए written consent चाहिए of both the parties. So just remember that. Here it is, both the parties seeking ART services as well as the donor. So you require informed consent of all these. The child born through ART will be deemed to be a biological child. Even though he is born out of ART, he is still considered, or she is still considered, a biological child of the commissioning couple and will be entitled to the rights and privileges available to a natural child of the commissioning couple. So whatever the rights and liability rights a child was having as a natural born child, or similarly as natural born means biological child, the same kind of rights would be given to a child who is born out of ART. A donor will not have any parental rights over the child. Donor is not going to have any kind of parental rights over the child. Now, the bill provides that national and state boards for surrogacy constituted under the Surrogacy Regulation Bill will act as national and state boards for the regulation of ART as well. So, the same board which is constituted for surrogacy will also see the work of ART regulating. So, they will also oversee the work of regulation of ART services. The same boards. No court shall take cognizance of the offences under the bill except by a complaint made by these boards. Now, this is very important. Even if you go and file a complaint against a donor or an ART service provider and you would want to go to the court, but court will not take the cognizance unless you have unless the national or the state board have given you the authority to do so. So if a complaint is made by the national or state board, then only you can approach the court. This is what this bill is all about. Now let's look on to the offences and penalties. Any kind of abandoning, leaving the child, exploiting the children born through ART, selling, purchasing, trading, importing human embryos or gametes, using intermediaries to obtain donors, exploiting commissioning couple, woman, or the gamete donor in any form, transferring the human embryo into a male or an animal. These offences will be punishable with a fine of 5 and 10 lakh rupees for the first contravention. So any kind of offense that they are doing pertaining to the either they are abandoning the child, exploiting the child, or any kind of exploitation of the commissioning couple or the donor or the woman. So any such things, or transferring the human embryo into a male or an animal, is also an offense, and the offense is punishable with 5 to 10 lakh rupees respectively for the first contravention. यानी कि पहली बार अगर ऐसा कुछ गलती होती है तो for that they will have 5 to 10 lakh rupees of fine. Now, any clinic or bank advertising for offering sex selective ART. Now, this is a very hot topic. Sex selective ART will be punishable with imprisonment of 5 to 10 years or fine between rupees 10 lakh to 25 lakh itself. So, in case of sex selective ART, what will be the fine? The fine would be 10 lakhs to 25 lakhs, and the years of imprisonment that you are going to have is then 5 years, extendable up to 10 years depending upon the gravity of the offense. So this is all about ART. Let's move on to the next thing. The Salary Allowances Pension of Members of Parliament Amendment Bill 2020. the bill is already passed by Lok Sabha and Rajya Sabha. The two ordinances were there in place of Salary Allowances Pension of Members of Parliament Act. ये जो टू ऑर्डिनेंसेस थे, इन्होंने ये दो लॉज को चेंज किया है. एंड व्हाट इज दोज लॉज? सैलरी अलाउंसेस पेंशन मेंबर्स ऑफ पार्लियामेंट एक्ट 1954 एंड द सैलरी एंड अलाउंसेस ऑफ मिनिस्टर्स एक्ट 1952 to reduce the sumptuary allowance of ministers by 30%, and the first one was for the salary part. Now why we have done it? Just in lieu of the changing times, we are going through a crisis, and that is why, to support the system financially, this amendment have been made to tackle the COVID-19 pandemic. And Article 106 of the Constitution empowers MPs to determine their salaries by enacting laws. Now, so what happened by the first bill, and that is, even if the salary is for 1 lakh rupees, the new entitlement, because we are saying there is 30% reduction, so they are getting 70,000 rupees per month. And the sumptuary allowance, which is, if it is suppose 3,000, it is getting reduced to 2,100 rupees for the Prime Minister. And similarly for the Cabinet Minister, we are having 30% reduction from previously 2,000 rupees. So that is what the entire bill is all about. Now, this next bill, which I'm going to discuss, is something very interesting. The Bilateral Netting of Qualified Financial Contracts Bill 2020. Now, what is netting? New word? Huh? The bilateral netting refers to offsetting of all the claims arising of dealing between two parties. So what can be offsetting of a claim? Example, suppose someone A has to give B rupees 500 and B has to give A 450 rupees. So what we do is we offset the claim. So finally, only how much will B give to A? So that is that amount, and that is netting. Netting refers to offsetting of all claims arising dealing between two parties to determine a net amount payable. A net amount payable or receivable from one party to the other. The bill allows for enforcement of netting for qualified financial contracts. Now, qualified financial contracts or QFCs, ये एक पॉइंट इन्होंने बोला, एप्लीकेबिलिटी बोली है, द प्रोविजंस ऑफ द बिल विल अप्लाई टू QFCs between two qualified financial market participants where at least one is an entity regulated by these. So what I mean to say is, even if you are qualified to become a QFC only if one party is regulated by RBI, SEBI, IDAI, PFRDA, or if. So what are these bodies? Reserve Bank of India, SEBI is Exchange Board of India, Securities and Exchange Board of India, Insurance Regulatory and Development Authority of India, Pension Fund Regulatory and Development Authority, PFRDA, or International Financial Services Centers or Authority, IFSCA. So this is what netting is all about, and this is all about this bill. Let's move on to the next bill. Seems quite simple. The Homeopathy Central Council Amendment Bill. Now, the bill amends the Homeopathy Central Council Act 1973. So, we have an act in place, right? And that act is Homeopathy Central Council Act 1973. The act sets up Central Council for Homeopathy, which regulates homeopathic education and practice. Now, what happened was, through this bill, we have just increased the supersession. The timing we have increased from 2 years to 3 years. The bill amends the act to increase the period of supersession of Central Council from 2 years to 3 years. So what we want is that the Central Council of Homeopathy to supersede from the Act. The 1973 Act was amended in 2018 to provide for supersession of Central Council of Homeopathy, and the Central Council was required to reconstitute it within 1 year, which did not happen, and hence we had another bill just to give them more time to supersede or take control. Right, so this is all about Homeopathy Central Council Amendment Bill. Let's move on to the next bill, which is Essential Commodities Bill 2020. So now the Essential Commodities Bill, or the Farmers Bill, which all are being passed, have been quite a lot criticized. There are advantages as well as disadvantages for both of them. But what was the main motive behind having these three laws in place was one India, one agriculture market in the country. So they wanted this one India, one agricultural market in the country, and that was their slogan as well. And that is why we have lot of amendments. We have passed two laws relating to the Farmers Bill as well as the changes in the Essential Commodities Bill. Now look very carefully into it. The regulation, the essential commodities does regulation of food items, and secondly, imposition of stock limits. Now, what is regulation of food items? Empowers the central government to designate any commodity as essential commodity. There is no particular definition of essential commodity in the Act. Whatever is mentioned in the schedule, and that becomes an essential commodity. Similarly, during the times of in the month of March and April, we declared what as an essential commodity: sanitizers and face masks. So whatever the central government decides becomes an essential commodity. So you don't have any particular definition to it. The imposition and curbs. So what is an essential commodity? It can include anything: food item, fertilizers, petroleum products. But right now, what this the amendment did was it deregulated certain essential commodities like cereals, edible oils, oil seeds, pulses, onions, and potatoes from the list. What does that mean? It means that these are no more essential commodities. After the bill is being passed, these are no more essential commodities. And the reason for deregulating them or removing it from the list was because India has surplus of all these commodities. Now, when the bill was passed, the original act was passed, which was 1955. During that time, we were having a lot of shortage of food grains and food products, and hence these were included in the essential commodity. But post this bill being passed, as Rajya Sabha and Lok Sabha has already passed it, these are no more an essential commodities. They have been excluded from the essential commodity list, and the reason that they have said or stated is that India has surplus of all these commodities. And also it becomes easier for the farmers to buy and sell outside APMCs. So that is why another reason they have removed it from the list of essential commodities. Now, imposition of stock limits. The Act empowers central government to regulate stock of any essential commodity that a person can hold, because there were a lot of hoarding being done, and that is why this Act regulates hoarding as well, and that what we call it is stock limit imposition. The bill specifies stock limit should be imposed only basing on the price rise. The stock limit may be imposed on agricultural produce if there is a 100% increase in the retail price in any horticultural produce. So stock limits किस पे बेसिंग होने चाहिए? स्टॉक लिमिट्स के डिसीजंस ऑन प्राइस राइज पे, और अगर 100% इंक्रीज हो रहा है रिटेल प्राइस में इन केस ऑफ हॉर्टिकल्चरल प्रोड्यूस देन, और इवन अ 50% इंक्रीज इन रिटेल प्राइस इन केसेस ऑफ नॉन पेरिशेबल एग्रीकल्चरल गुड्स देन एज वेल. Now the provisions of the bill regarding regulation of food items and imposition of stock limits will not apply to any government order under the PDS system. So this bill does not apply to any kind of government order under the PDS system. This bill is not going to apply to any kind of order which is under the PDS system or public distribution system. The move is expected to attract a lot of private investments in value chain of these commodities because we have deregulated it. Now a lot of private investments will happen in this sector as well. Let's move on to the next one. The Farmers Empowerment and Protection Agreement on Price Assurance and Farm Services Bill 2020. Remember the nomenclature very vividly. The Farmers Empowerment and Protection Agreement on Price Assurance and Farm Services Bill 2020. Now, the Farmers Empowerment and Protection Agreement on Price Assurance Bill, what does it say all about? The framework for farmers to engage in contract farming. Now, what is that? Farming as per an agreement with the buyer before you sow the seeds. So you're making a contract with the farmer is making a contract with a sponsor or any third party that before sowing the seeds, that contract will come into play, and under which the farmer sells the produce to the buyer at a predetermined price. So the farmer is going to sell his produce at a predetermined price to a sponsor. Now, who's a sponsor? The bill defines a sponsor as individuals, partnership firms, companies, limited liability groups, societies who may enter with an agreement with the farmer to purchase his farming produce. He or she is a sponsor. Who are they? The individuals, partnership firms, companies, limited liability groups, societies who may enter into an agreement with farmer to purchase a farming produce. जो भी farmer से purchase करना चाह रहे हैं उनका produce. Now this contract farming is basically before sowing of the seeds, you begin with a contract with the sponsor where you give them a predetermined price for the products that you're going to have. Now, the farming agreement. The bill provides for farming agreement prior to production or rearing of farm produce aimed at facilitating farmers in selling farm produce to sponsors. Such agreement may be between a farmer, a sponsor, or a farmer, a sponsor, and a third party. So, the entire bill talks about a farming agreement to make this process easy for the farmer to have that he gets the things at a predetermined, we fix it, and that is how the entire bill is all about. Now, duration of the agreement. The minimum period of agreement can be for one crop season or one production cycle of livestock, and maximum can be for 5 years. So, the minimum can be for one crop season and the maximum can be for 5 years. That contract agreement, how much time can it be for, right? For the production of cycle beyond 5 years also it can happen. The maximum period of agreement will be mutually decided by the farmer and the sponsor. If you want to have it beyond 5 years as well, generally they won't go for it, but if they want to have it, they can have a mutual agreement for the same. Now, exemptions from existing laws. The farming produce under farming agreement will be exempted from all state acts aimed at regulating sale, purchase of farming produce. Such produce will also be exempted from any stock limit obligations under the ECA Act. They are not bound by ECA Act. Dispute settlement. Now, any kind of dispute, if it arises, who will resolve it? The bill requires farming agreement to provide a conciliation board comprising of representatives of parties to the agreement and a conciliation process of settlement of disputes. At first, the disputes must be referred to the board or for their resolution. If the board is unable to resolve, so if the board is unable to resolve, then the matter will go to the SDM. If the dispute remains unresolved by the board after 30 days, then the matter goes to the SDM. So that is how the dispute resolution will be done under this bill. Now let's move on to the next one, which is Farmers Produce Trade and Commerce Promotion and Facilitation Bill 2020. It has already been passed in Lok Sabha and Rajya Sabha. We are just waiting for President's assent. Now it seeks to allow a barrier-free trade of farmers' produce outside physical premises of the markets. Now, what are APMCs, which are Agricultural Produce Marketing Committee laws? The bill will prevail over APMC acts. So the bill prevails. That means this bill will prevail over the APMC laws or acts, whichever is made. Now, what does this bill say? A barrier-free trade. Now, what is a barrier-free trade? Intra-state as well as interstate trade of farmers' produce outside. Both are allowed, Any physical premises of market yards run by state APMCs, other markets notified under the state APMCs, as well as any kind of collection center, farmer consumer markets. Now, under the bill, the trade of farmers' produce can be undertaken anywhere outside such markets, as in the places of production, collection, aggregation. कहीं भी जाके they can, sell their produce, and including farm gates, factory premises, warehouses, silos, as well as cold storages. Now, there was a very interesting thing was the market fee. With this bill, they have to pay no market fee. The bill prohibits the state government from levying any kind of market fee, cess, levy of farmers, traders, and electronic trading platforms. Even we have mentioned about electronic trading platforms for the farmers, and the bill says that there will be no fees that will be charged, as well as no kind of cess would be taken by the state government. Now, the Farmers Produce, Trade and Commerce Promotion and Facilitation bills talk about these four main features, which is farmers in the production produced by self or hired. Who is a farmer? Who's in self-production, as well as hiring some kind of a labor, and includes an FPO, which is Farmer Producer Organization. Any of them can be a farmer. An FPO means an association or group of farmers registered under any law promoted under or by state or central government. Now, the eligibility. Now, who are eligible for trade in farmers' produce? The bill allows all FPOs traders to engage in trade farming produce. Traders include anyone who buys farmers' produce for wholesale trade, for any kind of export, for processing, for value addition, for manufacturing, for retail, for end use, as well as for consumption. So these are anyone who buys farmers' produce for it. Now, payment to farmers. Now, how will the payment be done? The traders transacting with farmers must make payments for scheduled farmers' produce on the same day or within maximum 3 working days, providing a receipt to the farmers. So either on the same day or within the 3 working days, they need to make the payment to the farmers. Now, another new feature included was electronic trading platforms. Now, the bill for setting up electronic trading platforms to facilitate direct and online buying and selling of the farmers' produce, resulting in physical delivery of the produce. No fees to be levied by the state. Earlier, there was a state fees which was levied. Now, there is no fees which state can have. So, states are quite the most area where they used to have revenue was. Firstly, from after the GST, there was no kind of sales tax which was there, and post that, even in this bill, the revenue which state used to generate out of the agriculture is not given to them. So no fees is levied by the states. So this is what the farmers bill is all about. There were questions about certain students that why agriculture and trade being not included in the union list. Still, the parliament has made laws regarding it. Why? Because of Article 249 of Constitution of India. The central parliament has the power of legislation regarding any subject, any kind of subject, even in the state list, or if the center considers it to be necessary in the national interest, it can make laws regarding it. Now, the seventh schedule, as we all know, of the Indian Constitution has three lists: list 1, list 2, which is state list, and the list 3, which refers to the concurrent list. Now, what happens is entry 14 of the state list mentions about agriculture. Agriculture, what it states, agriculture as well as including agricultural education, research, protection against pests, as well as prevention of plant disease. Entry 14 of which list? State list mentions about agriculture. Still, Parliament has the power to make laws because of Article 249. Also, entry 33 in the concurrent list talks about trading. Production, trade, supply, distribution of range of foodstuffs and agricultural raw materials. And entry 34 talks about price control. So all this still the parliament has power to make laws for them. Why? Because of Article 249 of the Constitution of India, which says the central government has power to make legislation regarding any subject, even in the state list, if the center considered it necessary in national interest. So this is all about it. Let's move on to the next bill, which is Indian Institute of Information Technology Laws Amendment Bill 2020. Now, the bill amends, and what it does, it includes Public-Private Partnership Act. So what it amends two laws, which is Indian Institute of Information Technology Act 2014, as well as this Act, Indian Institute of Information Technology Public-Private Partnership Act 2017. Basically, what it does was very simply, it included four new IIITs into it, which is five new Indian IITs to set up under the public-private partnership mode. One would be in Surat, next in Bhopal, a third in Bhagalpur, fourth in Agartala, and the fifth one in Raichur as institutions of national importance. So any institution, if you need to declare it of national importance, definitely there would be changes in the laws which is there. So that is why they have made certain amendment to include these five institutes as institutes of national importance. Currently, these institutes are registered under the Societies or the Societies Registration Act of 1860 and do not have the power to grant degrees or diplomas. Now, after this amendment bill, these institutes, Surat, Bhopal, Bhagalpur, Agartala, and Raichur, will have the power to grant degrees and diplomas as well. On being declared institutions of national importance, the five institutes will be having the power to grant degrees. So this is all about this bill. Let's move on to the next one, the the Institute of Teaching and Research in Ayurveda bill. Now, the functions of the institute, we all know that once a lot of work has been done under the Ayurveda, and what we wanted through this bill was to regulate the entire teaching process for Ayurveda, probably the undergraduate and the postgraduate teaching positions, including pharmacy, to prescribe courses and course curriculum for them, to provide facilities of research in various branches of Ayurveda. So what we did was merger, the existing institutes will be merged into the institutes are. So we are merging these three institutes, all are located in Jamnagar, and we are merging these three institutes by virtue of this bill. The proposed institute will be situated to a campus of Gujarat Ayurveda University in Jamnagar. We were having three institutes which we are shifting to and merging them into a one institute. Now, composition of the institute, the bill provides that institute will consist of 15 members. Many members would be there. Just to mention, the Ministry of Ayush the Minister of Ayush will be one of the members. The Secretary and Technical Head of Ayurveda, Ministry of Ayush will be one of the members. Secretary and Department of Health, Government of Gujarat would be the member, and the Director of the institute would definitely be the member to constitute the composition. Now, the functions of the institute will have to provide teaching facility for providing undergraduate, postgraduate courses and all, and to hold examination and grant them degrees. Let's move on to the next bill, which is just passed in Lok Sabha, not yet in Rajya Sabha, and that is the Medical Termination of Pregnancy Amendment Bill 2020. Now, this bill regulates the conditions under which pregnancy may be aborted. The bill increases the time period within which abortion may be carried out. Very important. Earlier, what we used to have, that abortion was allowed only on opinion of one doctor if it is done within 12 weeks of conception, and this was what was done, and two doctors if it is done between 12 to 20 weeks of the conception. Now the bill changes and allows it abortion to be done on advice of one doctor up to 20 weeks. So even one doctor is eligible up to 20 weeks to grant abortion, and two doctors' reference is required in case of certain categories of women between 20 to 24 weeks. Now, another thing that the bill has added is the bill sets up state-level medical boards to decide if a pregnancy may be terminated after 24 24 weeks in cases of substantial fetal abnormalities. So this decision will be taken by medical boards. When there's any kind of substantial fetal abnormalities, the medical board will decide upon it. Rest for 20 weeks, one doctor is sufficient and two doctors sufficient for a woman having pregnancy in between 20 to 24 weeks. So this is what the Medical Termination Pregnancy Amendment Bill was all about. Let's move on to the next bill, which is Rashtriya Raksha University Bill. Not something much important, but the bill establishes Raksha Shakti University, Gujarat, which was established under Raksha Shakti University Act of 2009 as university called under Rashtriya Raksha University in Gujarat. Now, the bill declares the university to be an institution of national importance, and that is why we had this bill. Not much to include. They are also into educating them, having colleges, maintaining them, prescribing courses, granting degrees. So what they wanted to declare was just to declare it as a university of national importance, and that is why we had the bill. Now let's come to the next bill, which is National Forensic Science University Bill. The bill establishes Gujarat Forensic Sciences University, Gandhinagar, established under 2008 Act, and the Lok Nayak Jaya Prakash Narayan National Institute of Criminology and Forensic Science, which is in New Delhi, as university under the National Forensic Sciences University as Gujarat. So this is what the bill says. The bill declares the university to be an institution of national importance. The bill also repeals the 2008 Act, and the campuses of the university will include the campuses of the two universities, one which is in Delhi and the other which is in Gandhinagar. So these two institutes are also declared as Institute of National Importance. Now the National Medical Commission Act, I think, yeah, let's move on to the next one, which is the Companies Amendment Bill 2020. Now certain changes were made in this bill, and that was firstly, it removed a lot of penalty in certain offences. Considering this time of pandemic and lot of companies suffering because of it, so there were certain offences which were there, and because of which we had a discussion by our Honorable Defence Minister, and what she said, and accordingly there were certain changes made in the Companies Bill. Now, for example, it removes the penalties which apply for any change in the rights of class of shareholders made in violation of the Act. Note that there was a specific penalty not mentioned. The Act prescribes a penalty of rupees up to rupees 10,000, which may extend to 1,000 for a continuing default. Secondly, it removes imprisonment in certain offences, which was not correct, because during this time there would be a lot of laws which would not be abided, and hence imprisonment could have happened, and that is why they removed a lot of imprisonment as well. Now, under the Act, one person company or companies with only one member or small companies with low paid up capital and turnover thresholds are only liable to pay 50% of the penalty. So we have reduced the penalty for them, and which was quite important, otherwise they wouldn't have been able to survive. Now the bill extends this provision. Now what does the bill does? It extends reducing this penalty part to whom? To all producer companies and startup companies also, because there might be a startup company which has just started in March 2020 and not able to give up to the obligations that it is to do. So therefore, we have certain startup companies also to be reduced. Now, the limits of maximum penalty to 2 lakh rupees for the company as well as 1 lakh rupees for a defaulting officer. This is what the penalty that they have mentioned. And this is all about the Companies Amendment Bill. What they did was direct listing is also allowed for in foreign jurisdictions. CSR, which is a major part in any company, and how much CSR we should, a company having a net worth or turnover or profits above a specified amount are required to constitute a CSR committee and spend at least 2% of their average net profits in the last 3 financial years towards the CSR policy. Now, what does the bill does? The bill gives them exempts them, because not possible during this time of COVID. The bill, that is why it gives a relief to the companies, that a CSR liability up to rupees 5 lakh a year from setting up a CSR committee. So this is what 50 lakh a year from setting up a CSR committee. This is what the bill amends. Now also about the bench of NLAT, which is the bill seeks to establish national company law appellate tribunal, and most likely the seat would sit in New Delhi. This is what the bill talks about. Let's move on to the last and the final bill, and that is Epidemic Disease Amendment Bill. Mostly I've discussed in most of my lectures. You can go to the March and the April lectures simultaneously. And again, I'm discussing it considering the importance of it. So the original act is all of 1897. The original act is of 1897, which is Epidemic Disease Act 1987. The new provisions that we have inserted is 1A, 2A, 2B, 3A, 3B, 3C, 3D, 3E. The fun part about the bill was it was having only 4 sections. Now, what is an act of violence? The bill defines act of violence as an act of violence include the following acts against the healthcare service personnel. So act of violence is only against the healthcare service personnel. Act of violence, otherwise there is lot of act of violence which can happen anywhere. But the bill definitely defines it and clearly mentions against only healthcare personnel. Act of violence only against healthcare personnel. Now harassing, impacting living or working conditions, harm, injury, hurt or danger to life, obstruction and discharge of their duties as well, loss or damage to property or documents or the healthcare service personnel. So this is an act of violence according to the new bill. Now, as persons who is a healthcare service personnel, now the persons who are at risk of contracting, now not everyone, who are at the risk of contracting the epidemic disease while carrying out the duties. This line is very important. Anyone who is at the risk of contracting the epidemic disease while carrying out the duties related to the epidemic. They include public and clinical healthcare providers such as doctors and nurses, any person empowered under the Act to take measures and to prevent the outbreak. So this is one. So any person who is empowered under the Act also is a healthcare personnel who's been there to prevent the outbreak of the disease. And finally, any other person designated by the state government. So this is all about epidemic disease amendment bill. And let's move on to the next definition. Definition of property is there. Section 1A clause C defines property as defined and include clinical establishments, quarantine facilities, mobile medical units, and other property in which healthcare service personnel has direct interest in relation to the epidemic. Further powers are given to central government, and earlier the act used to have only the port. Now we have included trains, goods, vehicles, ship, vessel, aircraft, bus also, as well as, so the central government has powers to make regarding them as well. Now, Section 3.2 of the ordinance talks of the bill talks about no person can commit or abet the offence, and we have clearly dealt with it. So, what is the penalties that we are giving to them? Anyone who's committing or abetting violence, what kind of penalty they'll have? 3 months to 5 years or amount of 50,000 to 2 lakh rupees. This is what their penalty would be. So, imprisonment for 3 months to 5 years and a fine from 50,000 to 2 lakh rupees. Now, causing grievous hurt under 320 of IPC to healthcare professional. Now, if you're confused between what is hurt and what is grievous hurt, just look into my session of April and March month. I've explained it very nicely. Just go through it and you'll understand what is grievous hurt, the difference between grievous hurt and hurt. So what is them? Causing grievous hurt, 320 of Indian Penal Code, 6 months to 7 years of imprisonment and a fine of 1 lakh rupees to 5 lakh rupees. In case of damage to the property, what will be the fine or compensation that will be given? Twice the amount of fair market value of the damaged property as may be determined by the court. So this is all about Epidemic Disease Act. and the new bill which has come, and the persons convicted of the offence under the ordinance will also be liable to pay compensation to healthcare service personnel by whom they have been hurt. Such compensation will be determined by the court. Now, how will the investigation happen? Cases registered under the bill will be investigated by a police officer not below the rank of inspector. Within 30 days, they should complete the, after registration, they should complete the report. And trial, the inquiry and trial should be concluded within 1 year. When prosecuting a person for causing grievous harm or healthcare service personnel, the court will presume that person is guilty of the offence unless the contrary was proved. So this is all about the new bill, and these were the major portions that I wanted you people to understand. In case you have any doubt, just let me know in the comment section below. I'll clear all your doubts, and all the best for all your exams. Stay updated. There's nothing to worry, because even if we worry, there is no solution to it. So when we see this, mindset plays an important and the biggest role in the exam. Don't worry about it. Stay safe, stay healthy, and give the examination with mindfulness, with complete focus. That's all. Take care and stay healthy and stay safe. Thank you.